My name is Jeff Morgan. I'm from Dallas, Texas. I'm going to go over a case that I was sent last night. It is in the Supreme Court of Texas, number 19-0694, in regard to CJC Relator on petition, and this is a brief that was filed by the state of Texas as Amicus Curiae in support of Relator. This came out yesterday, and there appeared to be some excitement about it. I looked, a couple of people sent it to me, and some of the arguments were good, but the way that it was argued, I think, was a train wreck. So even though that there are some good things in here, we still need to look at the way something is argued, because the way something is argued can set us up for failure in the future. So the identity of the parties are listed here. Ken Paxton, Jeff Mateer, Kyle Hawkins, Natalie Thompson, who was a lead counsel, the Office of the Attorney General. These are the people who are writing the brief for the court as Amicus Curiae. The statement of interest is as follows. The state of Texas has an interest in proceedings involving the care and custody of the children within the state. The state's, quote, fundamental interest in such proceedings, quote, is to protect the best interest of the child. Now, I do not know where that comes from. I looked in the Declaration of Independence, and the Declaration of Independence does not talk about the best interest of the child. I looked in the United States Constitution. The United States Constitution did not talk about the best interest of the child. So I said, well, must come from the Texas Constitution. And I searched through the Texas Constitution, and once again, the best interest of the child is not found there. So how is it, where does it come into the mind of the state of Texas that somehow it is the state's fundamental interest in such proceedings to protect the best interest of the child? Again, it's not in the Declaration of Independence, it's not in the United States Constitution, it's not even in the Texas Constitution. Now, one source for the best interest of the child is this: the state must declare the child to be the most precious treasure of the people. As long as the government is perceived as working for the benefit of the children, the people will happily endure almost any curtailment of liberty and almost any deprivation. Now, wow, that sounds really great. Now, this actually came from Adolf Hitler. There is another place in which the best interest of the child is talked about, and that's in Article 3 of the United Nations Convention of Rights for the Children. The best interest of the child is the primary consideration of public policy. Then, of course, we have our own Texas Anti-Family Code. The Texas Anti-Family Code, which is over 1,500 pages, mentions the best interest of the child about 140 times, more or less. The interesting thing is that not once does the Texas Family Code define what the best interest of the child is. The best interest of the child, that definition, is very murky, to say the least. It's muddled, it's vague, nobody knows what it means. Therefore, the state can make it mean whatever the state wants it to mean. So this idea that the state's fundamental interest is in protecting the best interest of the child is nonsense. And then it goes on further and says the state also has a weighty interest in respecting and protecting parental rights, reflecting the fact that the parent-child share a commanding and fundamental interest in preventing any unnecessary disruption in their relationship. And that is true, except that the order is reversed here. The state actually has an interest in protecting the liberty issues and the parental-child relationship. That should be number one. This idea of the best interest of the child, what does that mean? Can the state of Texas please provide a definition for what they do? There is no definition. And once again, that's so that the state can do anything that it wants to. And like Adolf Hitler said, so long as the state declares the child to be the most precious treasure of the people, and as long as the government is perceived, doesn't have to be, but just perceived as working for the benefit of children, the people will happily endure almost any curtailment of liberty and almost any deprivation. Once again, it is important not just to look at the result, the opinion that is given by the people who are arguing a case, but how they arrived at this conclusion. And to start off by saying that the state's fundamental interest in such proceedings is to protect the best interest of the child leads us down a pathway to hell. This is not where we want to start at. The idea of the best interest of the child was used by even Adolf Hitler to justify some of the things that he did. And in another video, I will talk about some of the things that he did in the name of the best interest of the child. Anyway, but of course in our state of Texas, we would never do such things as what Adolf Hitler did. At least that's what we would like to believe. So here's what happened in this case. There was a father and a mother. They had a child. Evidently, they got divorced and they were never married. I'm not sure exactly what that relationship was, but the mother was petitioning the court to get a modification on child support. In the meantime, she was living with her boyfriend, who had become her fiancé for 3 months. Well, during the midst of this petition for a modification of child support, something happens to the mother and she dies. The child gets put back with the father. But alas, there is the boyfriend slash fiancé who wants to be able to be given rights to the child as well. Now, even though the boyfriend slash fiancé had nothing to do with the child being born, somehow because of his relationship with the mother, now he wants to have certain rights. In addition to that, there were grandparents, and the grandparents did play a very special role in the child's life. The grandparents were seeking some type of relief in this as well. The boyfriend slash fiancé has the initials JD. So the trial court held a hearing on JD's request to be named as joint managing conservator of the child with rights of possession and access. At the conclusion of the hearing, the court named the father the temporary sole conservator. But the court also ruled that JD would be a temporary possessory conservator. Among the rights the court awarded to JD was a generous visitation schedule that allowed grandparents unchaperoned access at the discretion of JD, the boyfriend slash former fiancé of the now deceased mother. And the court took it one step further. The orders that the court issued dictated a visitation schedule with detailed instruction for the surrender of the child to JD and grandparents. The temporary orders obligated the father to comply with these obligations at the threat of jail time. In its judicial discretion, the judge has decided that what we are going to do in the best interest of the child, we are going to tell the father, even though you're the father, you need to surrender the child to the mother's boyfriend slash fiancé, and also to the grandparents. And if you don't, by the way, we will throw you in jail. Some very major flaws were evident in the conclusion that the court reached. Number one, it disregarded the presumption that a fit parent acts in the child's best interest, and the fit parent was the father, not the boyfriend slash fiancé of the deceased mother, and not even the grandparents. The father was the fit parent, and the presumption is that he would act in the best interest of the child. Now, that's not always the case. That is the presumption. It should be rebuttable, but that is the case, that we do presume that good fit parents do act in the best interest of the child. Even though sometimes they blatantly don't, the presumption is that they do. So when the judge decided that he wanted to give all of these additional rights to other people, especially the boyfriend slash fiancé who had no biological relationship with the child in question, the judge did so over the objection of a parent. Imagine this. Imagine you have your children and somebody comes into your home and says, by the way, okay, these may be your children, but your neighbor over here, maybe somebody you don't even like, maybe a coworker, maybe somebody whose philosophy you disagree with, we're going to say Mr. or Mrs. So-and-so, these children now are going to be surrendered to these other people that you barely even know and that may not even care that much for the children, or that you may disagree with their philosophy. We're going to make sure that you surrender these children to this other person, or we will throw you in jail. That's exactly what was happening right here. Now, what was found is this. The trial court had abused its discretion in multiple ways, and that was the argument. The trial court had abused its discretion. Can you imagine in the state of Texas, family court judges ever abusing their discretion? I mean, the family court judges, these are the people that are all wise, all knowing, and all kind. They would never do something like abuse their discretion. They would never do something like act in ignorance. They would never do something that would be malicious toward one parent because the judge, whether it's a male or a female, dislikes one of the parties. They would never do something like this. But nevertheless, it was found in this case, the only exception in the state of Texas, perhaps, the court abused its discretion in multiple ways. In issuing the temporary orders as it did, the trial court abused its discretion. Abused its discretion in multiple ways. multiple ways. The brief continues. It says the trial court lost sight of the significant constitutional implications of this case. And this is good to hear, that finally at last somebody is acknowledging that in the court we should have some constitutional protections. The Constitution should govern the actions of abusive judges, and that if abusive judges or an abusive court violates the constitutional protections that we're supposed to have, those judges should be called out. In fact, if they do so intentionally and if they abuse their discretion in multiple ways, my argument would be that perhaps this judge should be removed. Perhaps he or she should be publicly sanctioned, perhaps rebuked, perhaps disciplined, perhaps be taken off the bench for a lifetime, perhaps even if it was done with malice in his or her heart, perhaps even investigated and possibly prosecuted because of his or her abuse of discretion, and as it said here, in multiple ways. Over the father's objection, the trial court made the mother's former boyfriend, J.D., a temporary possessory conservator and granted J.D. significant rights and duties backed by court order. Is that not abusive when a judge can rearrange your family at his or her discretion? A judge can say, well, you know what? I think that maybe this child should be with a neighbor, with a worker, with somebody you may disagree with. But this is what this judge did. It was a complete abuse of discretion. But of course, remember, he was acting, or she was acting, in the best interest of the child. Now, the brief talks about various other cases that took place. It talks about Troxel versus Granville. And by the way, Troxel versus Granville is not the law of the land. Troxel versus Granville is a plurality opinion that could be overturned. The Supreme Court does not make law. The Supreme Court may actually render an opinion, but a Supreme Court does not make law. So Troxel versus Granville is not law, and that is another flaw, I believe, in this brief. However, citing Troxel versus Granville, they argue that Troxel and its progeny traveled well-trodden terrain. It has long been a cardinal rule that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparation for obligations the state can neither supply nor hinder. So in Troxel, what it's also saying is, state, you have boundaries. You cannot transgress these boundaries. And judges in particular, these anti-family court judges who often abuse their discretion and bully people from their position of authority, where they sit as the all-beneficent, all-wise, all-knowing, they have limitations too. In fact, even according to the Attorney General in KP-0241, an opinion issued by the Attorney General, Ken Paxton of the state of Texas, February 22nd of 2019, he said that even if the state knows what's better for the child, it cannot act in such a manner and compel a parent to act in that manner. The state has limitations, and in fact, the state has the burden of proof to show why, when it does something, it is doing something. The parents actually have it's a liberty issue, it's an issue that affects the parent-child relationship that the state needs to protect and honor. Not looking out for the best interest of the children, but looking to protect the sacred parent-child bond, parent-child relationship, the sacred blood relationship that exists between these people. Furthermore, there is no suggestion in the record that the father was somehow an unfit person. He was not a terror. He was not somebody mean. He was not abusive. Nothing like that took place. And yet this judge decided to say, sorry, father, even though you're a great father, great dad, everything else, you get to have your child taken away from you, or you will be thrown into jail on my command. An abusive judge following a train wreck of a family code that we call the Texas Family Code, which often works against the interests of families. Once again, going further back to this court situation, although trial courts have considerable discretion. Oh, here comes the discretion, because remember, the judges have this wonderful thing called discretion, and they use their discretion in the most beneficent of manners. The trial courts have considerable discretion in making temporary orders for a child's safety and welfare in suits affecting the parent-child relationship. See, when you look at the thing like welfare, that has such broad interpretation, nobody knows what that means either. The state can interpret welfare to mean anything that it wants it to mean. However, that discretion is not without limits, constitutional and otherwise. So the judge has discretion, supposedly, because, of course, we must defer to the judges who have this wisdom. And again, most judges do not have any type of a degree in child psychology, sociology, family dynamics. But somehow, by virtue of the fact that this judge is there, he has imbued with his wisdom from on high. And we cannot question him, except that he has to remember that he has limitations to what he can do, both constitutional and otherwise. Now, the court did point out that the grandparents, to go to the grandparents now, the court pointed out that the grandparents had a very significant role in the rearing of this child. And, they were primary caregivers. They were providing for everyday physical and emotional needs. The child's mother was away for significant periods of time, and the grandparents were there. The grandparent relationship is not an unrelated third-party relationship. The grandparent relationship is a blood relationship. The grandparents are the parents of either the mother or the father, and the grandparents of the children. That is a very different thing than having a third party, such as CPS or an unrelated party coming in and claiming rights. Their grandparents should have rights to see their grandchildren, but more importantly, grandchildren should have a right to have that relationship with their grandparent. It has been proven again and again that grandchildren do better when they have strong bonds with their grandparents. However, to get back to the boyfriend, it is doubtful that a live-in boyfriend who was never the child's primary caregiver, the boyfriend was never the child's primary caregiver, and who had only occasional access to the child for a period of several months could ever, over the objection of a child's fit parent, be entitled to possessory conservatorship, given the constitutional presumption that fit parents act in the best interest of their children. Now, I'm not sure where that constitutional presumption comes from. It must be derived because, once again, that is not found in the United States Constitution, nor is it found in the Texas Constitution. It's not found in the Declaration of Independence. But we will grant that for right now, this is going to be the case. It's found in Troxel versus Granville, and a Supreme Court opinion, a plurality opinion. But we will grant that maybe they're right on this. The conclusion is this: trial courts must be cognizant of the serious constitutional implications at stake when awarding custody. And awarding custody, what is this award thing? Why should custody be awarded to anybody? There are two parents. The child has a right to both parents. If the state really wanted to act in the best interest of the child, it would take a different standard on what the best interest of the child means. The best interest of the child in the vast majority of cases is to be raised by his or her mother and father, natural mother and father, biological mother and father, in an intact home, and be supported by strong extended family and by a society that actually understands the importance of marriage and family. Anything less than that is not in the best interest of the child. So this idea about awarding custody, that is very seldom in the best interest of a child. The best interest of a child would be to be raised in an intact family with his or her natural mother and father, period. The best interest of the child is not to give the live-in boyfriend / fiance of the now deceased mother conservatorship rights. The boyfriend / fiance never was the parent to the child. The father was the parent. When you talk about the child's interest to parents, to know both parents, that's exactly what we're referring to parents. The child needs to know that he or she is loved by both parents. The child needs to know that both parents will make sacrifices for their children. And that does not include a boyfriend. It does not include a lover. It does not include a fiance. It does not include a third party. If anything, it does include grandparents, because grandparents are the same way as our uncles and aunts and brothers and sisters. Blood relations are completely different than non-related entities. So even though I do think that there are some elements of good in this brief, that has been provided to the Supreme Court of Texas, there is a lot of faulty rationale behind it. I would hope that we could fix this in the future. I hope that we don't get too deceived by saying, oh, this is wonderful. Look at what the Attorney General has done. Look at what his office has done. It is a mixed bag at best. It is not the wonderful thing that some people think it is. I think that we should acknowledge that it is progress, that the Attorney General and his office and staff are making progress toward a right interpretation, and I do hope that our legislature and our governor will get involved and get on the same page too, and start to actually talk about the best interest of the child. The best interest of the child is to be raised in an intact family with his or her natural mother and father, surrounded by strong relatives that love them, and also by being supported by a society that supports marriage and that hates and despises divorce. Thank you.